Good afternoon. Good afternoon, everybody, and welcome to this seminar on maternal imprisonment across borders. My name's Amelia Nice, and I'm a barrister at Doughty Street Chambers, and it's our great pleasure to welcome so many of you to this seminar on this very important subject. In fact, it was the work of our first speaker, Dr. Shona Minson, which was the inspiration for the seminar, as we heard her speak on Radio 4's Forethought over the summer, in which she was discussing what needs to change to prevent children being punished when mums are sent to prison. This seminar was then put together to reflect on the particular issues arising when considering that question in the context of separating parents from their children across international borders. We're aiming to keep to the 1 hour time slot for this webinar. There will be time for questions at the end, and please put your questions in the Q&A function at the bottom of the screen. Comments or observations can be then put in the chat. The webinar will be recorded and slides will be sent out later on. So it's my great pleasure to introduce our first speaker, Dr. Shona Minson. Shona is a British Academy postdoctoral fellow at the Centre for Criminology at the University of Oxford and author of the book Maternal Sentencing and the Rights of the Child. Shona is a barrister who practiced in criminal and family law before moving to the university to research the place of children in maternal sentencing decisions. She's produced considerable research on the issue and provides training to the judiciary. In 2019, she was winner of the Outstanding Early Career Impact Prize, awarded by the Economic and Social Research Council. Shona, over to you.
Thank you very much. It's very nice to be invited to be part of this. And it's interesting in the book that, Amelia, you've just mentioned, almost the final page of it, I say that I think the work I've done around sentencing of mothers in the criminal courts has application across immigration, asylum, deportation, and all those things. So I'm really delighted that we're now having those conversations across all these different areas. It's going to be a bit of a whistle-stop tour, but I'm going to be talking about sentencing and safeguarding and the separation of mothers and children in the criminal courts. Next slide, please. So what got me started in this area was noticing that we have differentiated treatment between children who are separated from their parents by the state in the family courts and those who are separated from their parents by the state in the criminal courts. So in the family courts, the Children Act applies. Section 1 says the best interests of the child are the paramount consideration of the court. The child has legal representation and has a guardian ad litem who acts on their behalf in proceedings. And if they have to be separated from their parents, the state will provide, train, and fund alternative caregivers for them through the foster care situation. In the criminal courts, when I began my work back in 2012, the situation was that the child might not even be mentioned in a criminal court when a parent was being sent to prison. And obviously, if that was the primary carer, there were serious implications for the child. Next slide, please. The rights framework that I used to analyse this issue was primarily based around the United Nations Convention on the Rights of the Child, but it's important to note as well that the Human Rights Act 1998 has Article 8, the right to family life, and Article 14, the right to enjoyment of rights without discrimination. In terms of the UNCRC, I based my work around Article 2, the right to non-discrimination, which in fact says that the state has a duty to protect children from discrimination or punishment that they face because of the status or activities of their parents. And it seemed to me that potentially we had an issue with children in the family courts being treated in one way and children whose parent happened to have committed a criminal offence being treated in quite a different way. And that concerned the respecting of their Article 3 right for their best interest to be a primary consideration, their Article 12 right to be heard, and their Article 20 right to special protection and assistance if separated from their parent. Next slide, please. So what are the impacts of maternal imprisonment on children? Because if there aren't serious impacts, then it really doesn't matter how we treat them. But of course there are. So a child with an imprisoned mother is likely to suffer more negative effects than a child of an imprisoned father, and the threshold at which their absence has an impact is lower than that of fathers. So even a very short sentence of imprisonment of a mother who is a primary carer can have long-lasting negative effects on a child. And we know that very many of the women in our prisons are there for quite short sentences. So we mustn't think that these sentences don't have negative effects on children. In my research, I looked at two areas of concern for the children. The first was the impact of imprisonment on the mother-child relationship, and the second was the impact of imprisonment on the child's well-being and future outcomes. The child faces physical separation, a change of home and carers, increased poverty, disrupted education, isolation, stigma, shame, effects on their future stability. They have difficulty visiting, they have changed behaviours, and they have what I identified as confounding grief. And I think it would be fair to say that there's really no aspect of a child's life that is left unaffected when their mother goes to prison. Next slide, please. In terms of longer term impacts, Mears and Sianek have talked about turning points where some event happens and it sets you on a different life trajectory. And in fact, parental imprisonment has been recognised as an adverse childhood experience. And children whose mothers have been in prison are less likely to be in education, training or employment in later life, more likely to have mental health and addiction problems, and likely to earn less than their counterparts aged 30. They are also, quite shockingly, more likely to die before the age of 65 than their peers. So these effects and disruptions to attachment at a young age do seem to have lifelong consequences. You may note I haven't mentioned intergenerational offending, which is very much what the government like to talk about. And that's because the research on that is quite old. It's not entirely convincing in all of it. There are likely to be structural and systemic issues which may well mean that children whose parents have been in prison move to become involved in the criminal justice system, but I don't think it's helpful for us to focus on that. Next slide, please. So what principles are there that have been established by case law? Well, first of all, we go to the case of P&Q, 2001 Lord Phillips, where he said the criminal sentencing of a parent engages the Article 8 right to respect for family life of both parent and child. Any interference by the state with this right must be in response to a pressing social need, in pursuit of a legitimate aim, and in proportion to that aim. The more serious the intervention, the more compelling the justification must be. And the act of separating a mother from a very young child is very serious. I interviewed Lord Phillips as part of my research, and he believed rather naively that everybody had been following this judgment ever since and there was no problem, but of course that's not the case. But it was set out really clearly 20 years ago what the court should be doing. In the case of Bishop in 2011, they said it's the court's duty to make sure it has relevant information about dependent children before deciding on an appropriate sentence. Next slide, please. In the case of ZH, which Lady Hale this afternoon said in a child rights lecture was one of her most proud cases, or the case she was most proud of in the Supreme Court, this said the welfare of the child should be at the forefront of the judge's mind. And then the case that most criminal lawyers, if they know of a case, will know about is Petherick, which was 2012, and said no standard or normative adjustment for dependent children, but their best interests are a distinct consideration to which full weight must be given. In a case on the threshold between custodial and non-custodial or suspended, a child can tip the scales and proportionate becomes disproportionate. And then in 2017, Modwadia said it may be appropriate to suspend a custodial sentence when the person being sentenced is the parent of dependent children. So there is a body of case law. Next slide, please. In addition, the sentencing guidelines have included since 2011 as a factor in mitigation, which can be considered solo primary carer for dependent relatives. The imposition of community and custodial sentences definitive guideline in 2017 put into the guidelines what was there in the case law about offenders on the cusp of custody and proportionate becoming disproportionate. Next slide, please. A rather surprising one is the 2019 child cruelty guideline, where they actually added an extra step into the guideline where the sentencer is to consider the parental responsibilities of the solo primary carer. Now, obviously, in these cases, very often the child of the defendant is the victim of the crime. And so I think they've taken the view that actually as a victim, they need to talk about their rights. But I find it quite perplexing, really, that in a case where the child may well have been, in fact, harmed by their parent, the court are being told that they really need to think about the relationship that parent and child have and perhaps avoid custody. I would like to see this step in all guidelines. And then next slide, please. The most recent and significant development has been the General Guideline Overarching Principles from 2019, which provides an expanded explanation for solo primary carer of dependent relatives. Now, whizzing through these, it's really taken what we've got in the case law and put it into the guideline. So they've got to think about whether it's disproportionate, they've got to think about the impact of sentence length. Sometimes judges will say, well, I'm going to send them to prison, so sentence length is irrelevant, but this says, no, it's not. It's always important. They've got to think about dependence when considering community sentences. They need to think about pregnant women, their health, and the effect of sentence on the unborn child, which I think is a very pertinent topic right now. Again, court has to ensure it has information. If there are not proper arrangements in place for the child, then the court should consider adjourning sentence to make sure that happens. And the court should also ask for a pre-sentence report in these cases. Now, the difficulty is that this is just an explanation that is there if a sentencer has decided they are going to think about this mitigating factor. There is nothing compelling them to do so, but if they do, this is what their attention should be brought to. Next slide, please. Obviously, there's the international rules, the Bangkok rules, which say a non-custodial sentence is preferable for women with dependent children. And if you're going to give a custodial sentence, you should only do that after considering the best interests of the child and making sure provision has been made for the child, and the UK is a signatory to that. Next slide, please. So in the research I did with the judiciary, it had two elements. The first was a transcript analysis of Court of Appeal decisions where women who were mothers had appealed either conviction or sentence. And in, I think it was 24 out of 27 of the cases that were overturned that I looked at, the Court of Appeal found that insufficient weight had been given by the lower courts to the matter of child dependence. So there seemed to be, in broad principle, an understanding by the Court of Appeal that this is something which the lower courts really should be thinking about properly. In the interviews I did with Crown Court judges, I've just summarised 4 things that I find, this is back 2016-17, and I think it probably hasn't changed a great deal. So first of all, judges don't take a consistent view on the relevance of dependence as a factor in mitigation. So I had a rating exercise where they had to say whether it was a 1 or a 10 in terms of how important it was. And it was the only mitigating factor that got both a 1 and a 10 from the research sample. So there certainly wasn't agreement around what they thought they should be doing with it. Secondly, their understanding of the guidelines and the case law, I think I was being quite polite here, but I said is limited and at times incorrect. So judges told me that there were no guidelines, that there was no case law on this, that they were in fact supposed to punish more harshly if somebody had dependents, that it was contrary to justice to think about children. So they really weren't well aware, and I think it's the advocate's job very much to bring these things to their attention. There were a lot of common misconceptions behind judges' willingness to make appropriate inquiries about children and to properly understand how their mother's sentences would affect them. Quite often those who had some sort of family law background were much more switched onto it, but very often they didn't know what they didn't know. They thought that, you know, only babies were affected or only teenagers were affected. The sort of age was one. They thought that socioeconomic status, the poorer you were, the less of a big deal it was if you sent your mum to prison. So there was a lot of trying to keep middle class families together and not other people. I could go on, there's a whole section in the book about this. And then finally, judges don't request a pre-sentence report as a matter of course when sentencing primary carers. There's quite a lot of evidence about this from the probation service. And it's something that the guideline now says they ought to, when they're sentencing a primary carer, they should be asking for a pre-sentence report. Next slide, please. So within the resources that I made films for the judiciary, for advocates, which the CBA had for probation, and we created this sentencing checklist. And I won't run through it now, but I think the slides will be available afterwards. But these are the kinds of things that you want to be asking a sentencer to have considered before they sentence a primary carer to custody, so that they've really understood the scope of what they're doing. Next slide, please. Original question, is there Article 2 discrimination against children whose mother's being sentenced? Yes, there is procedurally and there is practically. I'm whipping through these, so I won't give detail, but that's what I find. Next slide, please. this is just, I've called it a COVID addendum. I did research during COVID on what was happening to children whose parents were in prison, because there were prison lockdowns and therefore children had no contact with their parents. And this is just an infographic from that piece of research, which is available online. And I think that it's perhaps a helpful thing when you're talking about perhaps deportation cases or cases where a child will not see their parent. And it's quite easy to minimize how difficult that will be for a child if there's no real evidence of what that looks like. And actually this research provides evidence of what happens to children when they are without any contact with the parent in prison over a period of months. So I think that might be a useful resource for some people watching today. And then final slide, I think, just says, if you want more information, I've got a website, which is everything I've referred to, and there's a book. And thank you for your time.
Thank you so much, Shona, for a very compelling summary of some vital research, some of it pretty staggering, the references at the end towards some of the comments by the judges, and I look forward to some further questions on that. But moving swiftly on, our next speaker is Ben Cooper, QC. He is joint leader of the Chambers extradition team, and he was counsel for the successful appellant FK and her 5 children in the seminal case of HH in Italy. And this is a case which transformed the approach of the courts when faced with extradition cases in which a parent will be separated from dependent children. Otherwise, Ben has been involved in many leading extradition cases, past and present, including Gary McKinnon and Julian Assange, to name just 2. Ben, over to you.
Thank you, Amelia, and thank you, Shona. So I'm going to speak briefly, firstly, about the sea change of the courts, both before and after HH. I think it's important to understand how things were before, given the inconsistency of the application of HH since. And secondly, I want to touch on the guiding principles that HH established for judges and lawyers to follow. There's a lot of practical guidance within the judgment. Thirdly, there's the subsequent inconsistent approach of our courts in applying HH. And finally, some brief remarks on how best to prepare the court to safeguard the best interests of the child in the extradition context. Next slide, please, Ray. Thank you. And so just to give a flavour of the dismissive approach to Article 8 arguments that reigned for many years prior to HH, may be best encapsulated by this observation, which shows from someone prosecuting an Article 8 case involving a dependent child, where really demonstrates at the time the belief was that it would be wrong for defendant to benefit from their child's best interests in extradition. That culture has very much changed, and certainly the training of the judiciary of people such as Shona on all of the research that has come with that has made a huge difference to the culture. But as it was before, not so long ago, the House of Lords in Norris, Lord Phillips, explaining the legal test at the time, explained that you need some quite exceptionally compelling feature or combination of features in order to succeed on an Article 8 extradition case. And by way of an example from the first instance judgment in FK that was heard with HH, the Supreme Court, the judgment of the former Chief Magistrate Riddle, and how he approached the evidence in that case. He stated that with respect to Dr. Armstrong was the child psychologist who examined the children, and her report was relied on by the Supreme Court quite heavily in their findings. But it's illuminating to see how that evidence was approached prior to the Supreme Court judgment, and the judge stated that I wonder whether I needed an expert report to tell me that a family, and particularly young children, may well be devastated if the mother of the children is removed for whatever reason. As Mr. Cadman, who was prosecuting the case, points out, there's nothing in the lengthy report to suggest that the effect on the family would be anything other than that inherent in the removal of one parent as a result of extradition proceedings. And then as to the test, I agree with his assertion that there is nothing exceptional in this case to meet the very high thresholds set by Norris. And then next slide, please. We see that consistency of approach across all the courts. So in the case of the NatWest 3 case, which is the Birmingham case where Lord Justice Laws gave judgment, he applied a wholly exceptional case threshold. Thereafter, the House of Lords gave judgment in Huang, the immigration case, where it pointed out that a fair balance had to be struck between the rights of the individual and the interests of the community, and that the exceptionality test in Article 8 was not the right test to be applied. Now, Lord Justice Dyson, as he then was in the High Court in Jezo in Madrid, then applied that to the extradition context for the first time. He recognised that the exceptionality test was wrong and applied the Huang immigration formula, and notably explained, quoting Lord Justice Sedley from the immigration context, that that the difficulty of succeeding on Article 8 was recognised to be a consequence, not a precondition of the statutory exercise. But then a new test was formulated, which was equally almost insurmountable or very difficult to satisfy, and that was, and Lord Justice Dyson explained, although it was wrong to apply an exceptionality test in an extradition case, there will have to be striking unusual facts to lead to the conclusion that it would be disproportionate to interfere with the rights. So that was then being applied by the judges, looking out for striking and unusual facts. But at least exceptionality was gone. Then in HH, the joint cases, so HH and PH were the both wanted for cannabis trafficking and deemed to be fugitives. They'd been convicted in their absence. They had 3 children, and so the offences, the sentences passed were substantial. I think 8 and 14 years, and so that was on one side of the balance in terms of the public interest. Then the court had the contrasting case, which the magistrates' courts deal with in large volume of FK, involving more petty offences, dishonesty, stealing of clothes, of relatively minor fraud, and so on. 5 children involved, and expert evidence as to the ability of the father to care for the children and cope in the absence of his wife, the mother of the children, who was deemed to be the primary carer. And the certified question was for both joint cases. That's the next slide. Thank you. Where in proceedings under the Extradition Act, the Article 8 rights of children or the defendant or defendants are arguably engaged, how should their interests be safeguarded? And to what extent, if at all, is it necessary to modify the approach of Norris? And so the Supreme Court clarified as to the law that the question is always whether the interference with the private and family lives of the extraditee and other members of his family are outweighed by the public interest in extradition. The child's interest must be a primary consideration. The court needs information about the child and may need to consider mechanisms to ameliorate the impact of separation. Exceptionality is a prediction, not a test. And in assessing the proportionality of the interference, relevant factors will be the constant and weighty public interest in extradition, but notably the public interest is not always the same. If the delay was deemed to be relevant to the public interest and diminish the public interest, whilst at the same time increasing the impact, the Article 8 impact on the family. The gravity of the offences is generally a starting point in the exercise by the courts, and the UK is not to become a safe haven for fugitives. So those are the key considerations. The outcome on the facts of FK, the unanimous judgment of the court was that the effects on her extradition, the effects of her extradition on her youngest children would be exceptionally severe, and so they fully accepted the conclusion of the independent expert, the child psychologist, and the learning from other research relied upon by the expert as to that. although the offences were not trivial, they were deemed to be of no great gravity. And when assessing the public interest, the court could take notice of the fact that the Polish authorities didn't exercise discretion. The delay was important in reducing the public interest, as I mentioned earlier. And in the end, the public interest in extraditing FK was not such as to justify the inevitable severe harm to the interests of the young children in doing so. As to HH and PH, the impact on the children was outweighed by the public interest in extradition, given the length of the sentences. And it's notable that nevertheless, Lady Hale remained steadfast. She dissented, and in her view, the effect on the children of extraditing both parents in that case would be so severe that the proportionality required consideration of whether it could be mitigated. And so it was really notwithstanding the gravity of the offences, because there would be no parent left, that she was persuaded on that. And so.
And there's 3 minutes left. Sorry to interrupt.
Thank you, Amelia. I'll try and race through. So in short, HH provided a useful framework in terms of how to further investigate the best interests of the child, and when to involve the local authority, local services. The court had the benefit of extensive and detailed expert evidence and representation by the official solicitor, practice which has happened a lot less since. Moving on to the Committee on the Rights of the Children's interpretation, if I can just ask you to turn on again, please, and one more, please. We have here helpful practical guidance adopted by the Supreme Court from the committee, illustrating the substantive right, the interpretive principle, and the rule of procedure in the approach to Article 3 of the UN Convention on the Rights of the Child. And then next slide, please. The post-HH backlash. Immediately after HH, Lord Chief Justice heard 2 joint cases, JP and Czech Republic. And although the facts and the harm to the children of JP was arguably stronger than that in FK, the court had its own ideas as to how to interpret HH, and rejected the Article 8 challenge, finding the father could care for the children over a 10-month sentence period. But then the former Chief Magistrate, I should say, Arbuthnot, was then seized of the case after the Lord Chief Justice and discharged on Article 8 grounds when addressing the failure to remove on time and whether the CPS had shown reasonable cause for its failure to, or whether the NCA had shown reasonable cause for that, and reassessed Article 8 and followed HH rather than Lord Chief Justice in recognising the disproportionality of surrendering following the uncertainty that had arisen from the failure to remove on time. I give some further examples of post-HH cases in the slides that follow. The key point is to ensure that careful, detailed evidence is obtained from all family members, from schools, from doctors, from all professionals, that a good independent child psychologist is instructed, and where appropriate, the local authority. If there are concurrent care proceedings ongoing, it may well be to the defendant's advantage to obtain the factual findings from those proceedings, which may then tie the hands of the extradition judge with a definitive ruling as to the inappropriateness of alternative carers. And so there have been cases where the courts have been willing to allow the care proceedings to go first, but there's no hard and fast rule as to that. Amelia, I'm conscious of the time. I don't know if I have any time left.
I don't think you do.
Very well. Well, I hope you'll find the slides useful. If you, I don't want to take up the time of our illustrious speakers that followed. And so perhaps if there are any questions based on the slides at the end, we can return to them. Thank you for the time.
Thank you, Ben, and I'm sure we will all look forward to looking over those slides in due course. I will move swiftly on, and our next speaker is Camilla Zapata-Besso, who also is a barrister in Chambers. She will be looking at the separation of parents from young children in the UK as a result of immigration, detention, removal and deportation. Camilla is an immigration specialist regularly instructed to appear in immigration tribunals in asylum, human rights and deportation appeals for vulnerable adults, children and related JR proceedings. And she's also developing a practice in asylum claims involving national security issues and concurrent extradition proceedings. Camilla.
Thank you all. I'll be talking about the statutory scheme for how the Article 8 assessment is to be conducted in cases involving deportation of foreign criminals, and the Supreme Court's and Court of Appeal's more recent guidance on the tests relevant to the children of proposed deportees. I'll then deal briefly with non-deport cases and immigration detention. Next slide. So as any immigration practitioners watching this will know, sections 1178 to D of part 5 of the NIAA 2002 put on a statute what the public interest requires the court to have in deportation and removal cases where the court considers proportionality under Article 8. It sets out a number of exceptions to the general proposition in section 117C1 that the deportation of foreign criminals is in the public interest. So let's start with exception 2 on children. Section 117C5 applies where the C, the proposed deportee, has a genuine and subsisting relationship with a qualifying child being a British citizen or a child who has lived in the UK for a continuous period of 7 years. Of the British deportation on the child would be unduly harsh. Next slide. In KO Nigeria, the Supreme Court looked at whether, when considering what unduly harsh means, parental misconduct is relevant. The answer from the Supreme Court was no. The focus is on the child only. Why is that? Well, the public interest is already built into the statute. See paragraphs 12 to 23. Importantly, per Lord Carnwath, unduly harsh should not become too high a threshold. The Supreme Court approved the test in MK Sierra Leone, that the test was not merely uncomfortable or difficult. It was a considerably more elevated threshold. The addition of the word unduly raises an elevated standard even higher, but it was plainly less stringent than the test of very compelling circumstances, which I'll turn to after this section. Now, next slide. Turning to the Court of Appeal's 2020 judgments, in HA Iraq, the Court of Appeal focused in on the meaning of the unduly harsh test. In that case, both appellants were Iraqi nationals in settled relationships with women of British nationality and were parents to young British children. The first-tier tribunal had allowed both appeals, but the Secretary of State appealed. In HA's case, the upper tribunal had judged that HA's relationship with his children was particularly close and described him as a very much hands-on father, who was the primary and constant carer of the children. They would not be able to visit him in Iraq. However, the upper tribunal on appeal found that his deportation would not be unduly harsh because there was no evidence that its effect on his children and partner would be anything other than what is ordinarily to be expected by the deportation of a partner or parent. In the Court of Appeal, Lord Justice Underhill clarified the meaning of unduly harsh from paragraph 39 onwards, touching on KO Nigeria, observing Lord Carnwath's focus in that case being not primarily on how to define the threshold, and his statement that the degree of harshness will go beyond what would necessarily be involved for any child faced with a deportation of a parent should not be read literally. Underhill stated, "It is hard to see how one would define the level of harshness that would necessarily be suffered by any child. Indeed, one can imagine unusual cases where the deportation of a parent would not be harsh for the child at all, even where there was a genuine and subsisting relationship. The underlying concept is clearly of an enhanced degree of harshness sufficient to outweigh the public interest in the deportation of foreign criminals." Next slide. However, Lord Justice Underhill stated, whilst recognising the elevated nature of the statutory test, the statutory intention is evidently that the hurdle representing the unacceptable impact on a partner or child should be set somewhere between the low level applying in the case of persons who are liable to ordinary immigration removal and the very high level applying to serious offenders. Next slide. Importantly, there is no reason in principle why cases of undue harshness may not occur quite commonly. How a child will be affected by a parent's deportation would depend on an almost infinitely variable range of circumstances, and it's not possible to identify any baseline of ordinariness. Lord Justice Underhill held that the upper tribunal had proceeded on the basis that it was sufficient to say that the situation in HA's case was of a kind which quite commonly occurred in deportation cases. That was the wrong approach. The court also recognised the importance of taking into account evidence of emotional harm caused to children as a result of deportation and guarded against the pitfalls of regarding physical harm as intrinsically more significant than physical harm, per Lord Justice Peter Jackson at paragraphs 156 and 159. Also be aware that in relation to the second appellant, RA, the court recognised that in making the decision on the go scenario, that the relocation of RA's daughter to Iraq would be contrary to her best interest. The upper tribunal hadn't had sufficient regard to country evidence on that issue. Next slide. I'll deal with this point quickly. AA Nigeria repeats the point in HA Iraq that it's not possible to identify a baseline of ordinariness for the purposes of the unduly harsh test. Next slide. KB Jamaica is another interesting illustrative case. In that case, the appellant had 4 British children with whom he had a genuine and subsisting relationship but had separated from the mother. In a decision predating KO, the first-tier tribunal had allowed his deport appeal on the basis that it would be unduly harsh on his children. However, on appeal from the Secretary of State, the upper tribunal held that was an error of law. The question for the Court of Appeal was again the nature and level of the evidential threshold which must be met to satisfy the unduly harsh test. The Court of Appeal reiterated the principles in KO Nigeria and the unduly harsh test as clarified in HA Iraq and assimilated these at paragraph 15. I haven't set these out on my slides, but I recommend that any practitioner bringing these cases looks at the Court of Appeal's a summary of the relevant principles as set out in there because they're useful. Next slide. And then in TD Albania, most recently, the Court of Appeal again warned against applying a baseline of notional ordinariness. Next slide. I end this section saying only this: beware of 2019 Court of Appeal judgments, so those predating the judgments I've cited so far. In HA Iraq, counsel for the Secretary of State relied on these cases, and whilst Lord Justice Underhill stated that they mostly turned on issues peculiar to the particular case, and none had called for the kind of analysis required by the grounds of appeal before the Court of Appeal in that case, he nonetheless found nothing in them which was inconsistent with what he had said. I can't go through the facts of each of these cases because of the time constraints on me, but I only caution that in JG Jamaica, a very high detrimental effect on the psychological well-being of children was found to meet the unduly harsh test, whereas in PG Jamaica, it was not unduly harsh for the father of 6 to be deported, despite on the face of it, there being compelling aspects to his relationship with his children. Practitioners should be aware of these judgments and remember the enjoinder of Lord Justice Underhill that how a child will be affected by a parent's deportation will depend upon an almost infinitely variable range of circumstances, meaning none of these cases should be treated as a touchstone, and a holistic assessment is still required on the facts of your particular case. Turning briefly to more serious offenders, next slide. Section 117C6 of the NIAA says that where a foreign criminal has been sentenced to a period of imprisonment of at least 4 years, so 4 years or more, the public interest requires deportation unless there are very compelling circumstances over and above those described in exceptions 1 and 2, and I've already dealt with exception 2. Next slide. The key authority on this is NA Pakistan. That's in the slide. I'm not going to go through it because it's a 2016 authority and immigration practitioners will be well aware of it. Next slide. Now I'm swiftly moving to the reasonableness test, which is applicable in immigration removal non-deportation cases. Next slide. Section 117B6 of the NIAA sets out the public interest considerations applicable in all removal cases. It states that in the case of a person not liable to deportation, the public interest does not require removal where they have a genuine and subsisting relationship with a qualifying child, and it would not be reasonable to expect the child to leave the UK. So that considers the scenario of the child leaving only. So if the child can't leave, then nor can the parent. Next slide. Back to KO briefly. In that case, Lord Carnwath had held that the parent's conduct is irrelevant to the reasonableness test, as I've stated, except to the extent that it has led to their not having leave to remain. And therefore, it will be indirectly material to the reasonableness question, because the reasonableness question has to be considered on the hypothesis that the parents will have to leave, which is the so-called real world point. And normally it will be reasonable for a child to leave with their parents. Next slide. I'll deal with this short pointly. In AB Jamaica 2019, the Court of Appeal noted that reasonable to expect is not just a prediction of future occurrence, it carries a normative force. Next slide. In Runa, the Court of Appeal recognised that if Section 117B is not satisfied, a proportionality assessment is still required. It's a benevolent provision which has the effect, in a case where it applies, that the public interest is treated definitively as not requiring the parent's removal. It can only operate in the proposed removed parent's favour in that regard. But of course, if a child doesn't meet the requirements of it, a full proportionality assessment is still required. And that will, of course, apply to younger children under the age of 7. Next slide.
Just a minute or so left, please.
And turning to the most recent authority in this regard, NA Bangladesh of 2021, this confirms that even where the child's best interests are to stay in the UK, it may still not be unreasonable to require them to leave, applying the Zumbas point and MA Pakistan, and considered the situation where both parents are facing removal. Lord Justice Underhill stated that in a case falling under the 7-year provision, where neither parent has leave to remain, the starting point for a decision maker is the common sense proposition that it will be reasonable to expect the qualifying child to leave the UK with their parents. And in that case, the Court of Appeal held it reasonable to expect a UK-born 11-year-old to go to Bangladesh with his parents. I end with this. As always, expert evidence is essential to meet any of the thresholds I've cited, whether it be best interests, reasonableness, or very compelling circumstances, or undue harshness, of course. Country expert evidence on education, children's rights, parents' employment prospects, discrimination, etc. in the place of removal is useful. School reports are useful, but what is essential is an independent social worker report. And in certain cases where there are concerns that the parent's removal may have an effect on the psychiatric well-being of either the child or the parent they'll remain within the UK, psychiatric reports as regards those effects are also essential. My next slide deals with the main authority on the relevance of the best interest of the child in the detention context. In short, it needs to be considered in the context of the wider Heidiel Singh type assessment. A failure to consider it at all is a private law error per MXL and others of 2010. That concludes my presentation. Please feel free to contact me with anything arising.
Thank you so much, Camilla. Really interesting to hear about the different cases addressing harshness and reasonableness in their decision making. But moving on, our next speaker is Naomi Jackson, and we're very lucky to have her join us from Social Workers Without Borders. Social Workers Without Borders was formed in 2016 when a group of social workers went to Calais and realised there was a need for social workers to provide best interest assessments to support unaccompanied children's applications to enter the UK. Naomi will speak about her work in undertaking assessments for families, the use in court proceedings. Naomi is herself a social worker whose background is in working with children and families in safeguarding. Naomi, it's over to you.
Oh, thank you. Thanks. It's really great to be here this evening, and on a panel with such fantastic speakers before me. They've been really interesting. So I'm going to talk about the work that we do at Social Workers Without Borders in the context of deportation, and thinking about maternal imprisonment and separation of mothers from children. So next slide, thank you. So just a little bit about us as an organisation. So like Amelia said, we were formed in 2016 when a group of social workers came together, and we went to Calais and realised that there was a need for social workers to provide best interest assessments to support unaccompanied children's applications to enter the UK. In 2017, we registered as a charity, and we shifted the focus of our work to be here in the UK, realising there's actually a huge need for these best interest assessments. And we're now working across a range of different immigration and asylum matters. So reunification cases, asylum appeals, deportation cases, challenges to spousal visas that don't meet the sort of spousal visa requirements, children who've been in the UK for 7 years or longer, applying for settled status, age disputed children, and a very small amount of assessments just for adults, not for children, for adults with multiple complex needs. So yeah, that's what we do now. We provide social work assessments on a pro bono basis where somebody isn't legal aid funded. So sort of like supporting people to have access to justice. And the majority of our assessments, like probably about 95% of them, concern children's best interest. And these best interest assessments are really what we have a focus on in our practice. And probably about 20 to 25% of our cases concern deportation and a child, or an assessment for a child whose parent is facing deportation. We're a national network of volunteers, and just kind of a recognition of what fantastic volunteers we have, really brilliant case coordinators, social workers and social work students. And the way that we work is we have some really dedicated, experienced case coordinators who will supervise a social worker to be the lead assessor, and then they will have a supporting assessor who will be usually the less experienced social worker or a social work student. So we work in these small teams to produce reports. And there's just to say there's a bit of probably a difference than for solicitors who are maybe preparing your clients for having a social work assessment with an independent social worker. It's just sometimes worth reassuring them that we're able to practice in a different way. And I think as I go through my slides, you'll see that we really take a rights-based approach to the work that we do. And this can be quite different when we're not working in the pressures of the local authority. So sometimes people do need a bit of reassurance if they've had a bad experience with a social worker, that the way that we as independent social workers are able to approach our work is a bit different to the experiences they might have had in the local authority. So it might just be a conversation that's worth having with your clients sometimes, can be really reassuring. Next slide, please. So I'm not going to talk about this a lot because as a expert witness, it is absolutely not my role to make the legal arguments or take the role of the advocate. And Camilla's done a fantastic job before me talking through these different judgments. But I do just want to mention HA and RA Iraq judgment, and just because it's really important for what I'm going to talk about. So previously we had the KO judgment for the sort of defining what that unduly harsh test was, and we would have been looking for more kind of exceptional circumstances to evidence that. And now with the HA judgment, there's a recognition that it's really on a case-by-case basis, and that you need to have an assessment of children because they're all unique. And just to increase the emphasis on emotional harm and sort of not having this hierarchy of types of harm. All different harms or types of abuse or harm can impact children, and that's really important to consider. So that's why social work assessments are potentially a really useful piece of evidence for you. Next slide, please. So what I thought might be, we skipped. Okay. So thank you. What I thought would be helpful today for solicitors in preparing your cases and kind of thinking about the practicalities is to know a bit about how we approach best interest assessments, and then really what we find really useful in the bundle, and will help you think about preparing that bundle and instructing an expert witness, a social work expert witness. Next slide, please. Thank you. So the first point about social work assessment is the importance of the triangulation of information. So the better the kind of evidence that we have in the bundle, and the more our assessment is able to draw on other sources of evidence and corroborate what a family is telling us, the more credible our report is. And so where possible, this should be a multidisciplinary approach to children's best interest assessment. So it's really helpful when we have information from education professionals, health professionals, and that really strengthens our report. So if that's included in the bundle, but also if we can have a conversation with other people that know the child, that really makes a much better report in we find. And it's really important before we could phone up a school or a health visitor or something that we have consent from the family to do that. So that's sometimes, especially when we're working in quite a time pressured way, just things to think about at an early stage. Next slide, please. So thinking in line with the kind of the KO Nigeria kind of thinking around what we're looking for in a best interest assessment, and we might have sort of previously gone for kind of risks and harms and these kind of extra factors. It goes without saying that there is still compelling evidence and absolutely something to be considered, but it's not the whole picture. But I just wanted to think about, so kind of harm that happened in the past and information that we have about that is really important, even if it's not a presenting factor for the child now, because it can be really indicative about how they might cope with future adversity. And children who have experienced past traumatic experience have sort of increased vulnerability. And we really need to take a preventative approach for those children, knowing that there's potentially sort of less resilience there. And then just thinking about future sort of risks and harms, that if we need to sort of have evidence-based kind of predictions into the future. And I just put a link there for BID, because they've got some good resources. There's a report there where they've done a literature review that people might find helpful, especially if they're preparing their own case. And then another important point that I think we should all be thinking about all the time when we're thinking about safeguarding and welfare of children is delay and the impact of delay. It's absolutely sort of fundamental to what it is to safeguard children. It means making the right decision for children in a timely fashion. It's there in the preamble of the Children Act. It's there in General Comment 14 about what is best interest. And I think in immigration and asylum law, it's something that we see a lot for children, just decisions taking a really long time. So I think we should all be it can be really helpful to just really think about the impact of delay on children and the principles of safeguarding. Next slide, please. So I've done a kind of brief overview of our kind of rights-based approach based around the guiding principles of the UNCRC, and I'll just whiz through this slide. But so it's really to our kind of passion and kind of shock for this kind of discrepancies in how children's best interests are considered. For lots of us in Social Workers Without Borders, it's really drawn from our experiences in children and families social work and seeing how kind of all the processes and protocols and legal requirements around making life-changing decisions for children in family law, and then just this kind of lack of safeguards in other kind of legal arenas. So we're really interested in that comparison, and we're working with some fantastic law academics, Professor Helen Stalford and Dr. Nazia Yacob at the European Children's Rights Unit, to do a piece of research. So if anybody, you can read that on the slide and you'll get them for yourself, do get in contact with us and we can send you more information. Next slide, please. And just so the best interest principle, and this just is really reinforcing from the HA judgment, and this need for it to be on a case, an assessment has to be on a kind of a case-by-case decision. It's this kind of dynamic process for children. So we're strongly of the view that it's our opinion that cases concerning children should not be decided until an assessment of the impact on the child has been completed. So this is what best interest is. You know, it says all through general comment 14, it needs to be assessed and considered. So we think a social work assessment is a really vital piece of evidence to ensure that we're making decisions in children's best interest. Next slide, please. And then just thinking about the child's right to development. So what we do is social workers and social work assessments are grounded in child development theory, giving consideration to the kind of age and stage of a child. So children's development is inseparable from the quality of care and the relationship that they have. So how does the impact of a potential loss of a primary carer impact a child? And development is forward-looking. What do children need to thrive and grow and achieve their potential? So it's really helpful for us to have evidence in the bundle, not just about things that are kind of adversity and difficult for the child, but what good things are happening in their life and what supports their development. So from schools and clubs and community, what opportunities do they have to learn and grow and play? And importantly, what role does their parent play in supporting their development and their access to opportunities? So including those things in the bundle is really helpful. Next slide, please. And then, yeah, Article 12, the child's right to be heard. So it's really important. We can't make best interest decisions if we're not listening to children. And this is really fundamental. And so for children who are able to verbalise their views, it can be really helpful to work with a social worker or a professional to share their views and think about doing that in a really child-friendly way. So, you know, examples, sometimes children will draw pictures with us. I've worked with children, they've written poems about how they feel about a decision, things that maybe they might not do in another context or without working with a professional who's really working in a child-focused way. And then it's just really important to recognise that even if you're not a verbal child, for a baby or very little children or some children with a disability, they still have a right to have their views considered. And we have to use our sort of expertise in infant observation and child development to kind of tease out, well, what would they want? What does that look like? And what are we seeing? And that's really important. Amelia asked me earlier, what is maybe a question that we sometimes don't see on a letter of instruction that probably should be there? And I think it's probably what's the child's views. I think sometimes that's really missing and it should be at the forefront of best interest decision making. And then now next slide, please. I'm really conscious of our time. The really sort of key to what we're thinking about when we're thinking about separating children or the possibility of children being separated from their parents is the child's right to family. And something that's really unique about children is their need for relationships, their need for care. And for their development and survival. Like, they will die if nobody cares for them. So what is a relationship? So I think is unique about social work assessments is the way that we can kind of tease out the dynamic nature of families and relationships. And it is not, when we're in a relationship with somebody, it's a kind of feedback loops. So that's kind of what we're observing, that kind of interaction. So it's relationships and action. And I just put a point in here as well, just to say that sometimes there's something we see from the Home Office is this idea that children can maintain relationships remotely. And that's just nonsense, really. Children need physical affection to help them, and touch to help them learn to regulate their emotions, and they need play to do all the kind of learning and development and all this cognitive stuff. And from a very young age, that's like holding your child's hand and helping them climb on something. It's children need togetherness, so kind of we'll flesh that out really in our assessments, and why that's so important in child development. Next slide, please. So my final slide, and I think this is really important, is just the power of empathy. So a sense of empathy is really important in humane decision making. These decisions aren't entirely rational, even though we might apply tests to them. There is an affective component. When we feel something with somebody, I think we make a better decision for them. So I think it's really important that the decision maker has a sense of knowing the child and their family and having a degree of compassion for them. So these kind of observations of normal family interactions can be a really powerful way to bring people alive on the page. So I'm sort of watching a family and I'm thinking, when did I really feel something for them? Or when did I feel like I saw them together? And then I will describe that in my report, because I think it's just really important. And I think that's about how we use words can really change the tone of something, and we should be really mindful of that. And that's something that I hope social work assessment brings to your bundle of evidence. But I also think it's something to be mindful of in witness statements. So I've read lots of different witness statements and bundles, and sometimes I read a witness statement and I think I have a sense of somebody and who they are, and sometimes I read them and I think, oh, that's written by their solicitor. So I just think that's the importance of empathy is something that we should bear in mind. And next slide, please. And just to say, if you want to make a referral to us, email this email address and request our referral form. Thank you.
Thank you. Thank you so much, Naomi. What a powerful point to end on. I think certainly from an advocate's perspective, if you can engage the empathy of the judge, you've got perhaps a better chance of them giving the family or the child the attention they deserve. So thank you very much. We are at time, but I think I might just use my chair's prerogative to ask a couple of questions, if that's okay, and unless I see any wild objections. The first one I wanted to direct at Shona, I think primarily, and that was the research that you refer to, both your own and also the external research, including that referring to premature death of those whose parents are sent to prison, is so compelling. And that piece of research in particular is quite staggering. And I wondered if you can say how that research is greeted in the training that you have done for the judiciary.
Thank you. Yes, sentencers are usually pretty shocked. I think that would be fair to say about all that I tell them in training, that this isn't something that people have understood. So I find that when sentencers were thinking about sending a mother to prison, their thinking about dependence only got as far as an understanding that the mother and child would be separated from each other and they would live separately in two physical spaces. And when I asked them to think beyond that, they really couldn't get much further. And so the thing that was interesting was that care was the tipping point. So if they thought there was no one else who could take care of the children, and they really believed that, then that was they knew that wasn't a good outcome. But they could be told there was a family member, and often the courts really pressurized people to come up with somebody to look after children because they were so avoidant of a care scenario, and they didn't believe people who said they didn't have someone. But actually people very often don't have someone that could take care of their children for a couple of years or months or whatever. But the judges almost, it was off their conscience if they could find someone who wasn't the local authority. But so I think telling them about actually the range of harms that children suffer and that they impact their entire lives has taken them aback. So the more that this research can be used, and the more that we can actually say, here's the reality, because before I did my research, I felt that sentencers were being asked to contemplate an imagined future, because there was no research saying this is what happens to children whose mothers go to prison. But now we can say, here is the evidence, this is what we know will happen to children, and this is what you must consider. We're not asking you to fictionalize this, we're telling you the realities. So yes, they've taken it quite seriously, I think. But of course, it's an issue with getting people to listen and enough people to be thinking about this, which is where it comes down to advocates, really.
Well, I was going to say, and does your research or the feedback that you get from the judges suggest that advocates always raise the issues as they should?
It would suggest they do not.
Yeah, okay, that's really interesting. The second question I had is really directed at everybody, and I wondered if you could say, if you had one ask that you could make of the court system from your own differing perspectives, what would it be? And this may be in fact, looking at the time, I think this will be the question we end on, so it's a chance to make a concluding comment as well, if you'd like. Shona, would you be able to
I'm happy to go first. I would ask that either they put that step 5 that's in the sentencing guideline on child cruelty, that was in every guideline, that they had to consider the parental responsibility of the person, or that we had some sort of separate guideline saying this must happen, or it was in statute that actually a child's best interest must be considered by any sentencing court, and let's extend that to deportation, immigration, all the rest of it as well.
Naomi?
I think my ask would be that we strengthen the Section 55 duty by putting something like the welfare checklist onto the statute, so everybody's really clear what that means, and we have a checklist of things that we need to be doing when we're making decisions about children and immigration and asylum law. And I would also, can I have two? Every child would have an assessment, an actual meaningful assessment of their needs and rights when we're making life-changing decisions about them.
Those are two very important to-dos. That's a good ending point. Ben?
So I think based on Shona's interviews with judges, probably I'd say all of the tools, all of the legal tools are there. It's just a question of how to apply them. And so clearly regular and frequent training of the judiciary and the legal profession is probably the most important way of achieving the right outcomes.
Here, I would back that. And Camilla?
I'd say there are two. The first is a clear move away from the 2019 line of Court of Appeal case law, which puts the unduly harsh test very high in terms of its application of the facts in those cases to the test. And also, I think more force from the tribunals in directing litigants in person to solicitors in complex deports involving children. One of the most heartbreaking things is the amount of litigants in person I see at case management hearings who aren't represented, who bring these cases and do not know just how much of a difference expert evidence, which they need legal aid for and which they may be eligible for, if the right solicitors make the application, would help their case. So those would be the two things.
Yeah, very powerful. All right, well, thank you ever so much, everybody. We are out of time. We're at the end of our slot. I think it's been wonderful to hear from everybody, and it's important to reflect on the progress that's been made to date, as well as everything that lies ahead. So many thanks again to all our speakers, and thanks to all of you who've joined us, and we look forward to seeing you again soon. Bye-bye.
Thank you.